Here's what I know, and you're right, I don't know you. Here's what I know. The allegations that have come before the court is that there is a domestic violence situation which precipitated itself or continued into another day and involved a firearm. That's what I know.
You're not. It didn't. It never involved. Judge, for what it's worth, the firearm was found. There was no evidence that a firearm was pointed at anybody. It's just that a firearm was
My
found.
understanding is it was brandished.
Oh, Judge, I don't believe that at all.
It was found.
It was simply found that the weapon was licensed to the victim.
She violated the no contact order 74 times, and now her lawyer thinks she should get more phone privileges? Seriously? What's next?
Attorney who's standing to my right.
Good morning.
Your Honor, the PCT, my client wishes to set this matter for a preliminary exam. And if
All discovery is complete.
yes, Your Honor.
You were going to say something. Huh?
And if I'd like to, when appropriate, address the condition of the bond.
Right. People would have their witnesses available July 2nd.
We'll do our best.
Preliminary examination in person will be set July 2nd, 2024, 9 a.m. That is before Judge Washington. Yes, Esteban.
Your Honor, my client is serving currently a less than a year sentence from Judge Barr right now. And the complaining witness for the felony portion of this current case that she's hearing today, the complaining witness is the father of her 3 children, and she is currently pregnant and is due in October. I understand that I've substituted the no contact with Mr. Greenlee, who is the complaining witness on the felony. He is the father of the children and the child to be born in October. My client, and I believe Mr. Greenlee, is in agreement if the court would be willing to waive or to amend the bond condition to allow her to have contact with him, phone calls from the jail.
Your Honor, it has been communicated to our office that we would like contact. I am opposed to that in this case. This is a case where I do believe Ms. Barney's phone privileges have been revoked because she contacted the victim 74 times in violation of the no contact order through jail calls. So I don't think that any modification of bond conditions are appropriate in this case.
Your Honor, if I could address that. So if they're monitoring all her calls. So if there's an issue with her calls, then certainly they have things they can do. Otherwise, given the background of the family background, the fact that she's due in a few months, I'm not sure what they're expecting from that. Certainly,
How long is she in custody?
How long has she been in custody?
Well, no, I guess.
This is the full year on the child abuse case before Judge Barr.
So I think that was in April.
That's correct.
May 15th. So there is a pending motion up in front of Judge Barr to change that, given she was denied access to the mental health court. So that is being addressed with Judge Barr right now in a couple of weeks or next week. But having contact with there's no way for her to check on her children. There's no way for her to talk to about her health. There's all these issues going on that communication.
What are the prohibitions on the child abuse case? So, I mean, I know she's under sentence, but
She has been sentenced to jail. Judge Barr was considering modifying the jail sentence if she were to be accepted to mental health treatment court, from which she has been rejected.
To answer your question, it's not about contacting the children. I don't think there's a no contact with the children. Or him. There's not a no contact in any of the cases. So that's why we're wondering why she's being.
Is that correct?
I'm not certain. If you give me a moment, Your Honor, I can check the notes.
She violated the no contact order 74 times, and now her lawyer thinks she should get more phone privileges? Seriously? What's next? An award for breaking the rules. Meanwhile, the judge is just sitting there, probably wondering if common sense has completely disappeared.
While they're checking that, typically I would need to hear directly from the alleged victim in this case before I would change anything.
He's here, Your Honor, if you want to speak to him. My understanding of the no contact order, or that issue, Your Honor, was no non-consensual contact with Mr. Greenlee.
Your Honor, my understanding of the prohibitions in the child abuse case, according to our notes, is that Ms. Barney was allowed to have contact through CPS, which was to be facilitated by the victim in this felony case. With the no contact order in place in this felony case, any facilitation of visitation through CPS facilitated by the victim here is not occurring.
So before she went into custody, she got from the family court, she got an order for completely unsupervised visitation with all her children. That's a court order from the circuit court. And the issue is more of the contact with Mr. Greenlee and having contact with him so that she can find out how everybody's doing. Education, medical decisions. He wants to check in on her. He is present in the courtroom if the court would like to address with him. But this is, I'm at a loss to why these two can't talk to each other. Certainly the prosecutor has the right to look at all their phone calls and see if there's anything inappropriate said while the case is existing. But beyond that, I don't understand why they can't talk to each other.
I'll indicate no non-consensual contact. I don't know that necessarily addresses, and I'll let Judge Washington address whether or not her phone privileges at the jail will be reinstated. But I'll order no non-consensual contact.
Thank you.
Court does call the case. People versus Carrie Dillard.
Project on behalf of Mr. Dillard, Carrie, would you state your name for the record once you're at the podium? Carrie Dillard.
Thank you.
Judge, I'm asking that I'm representing him on both matters. We're asking that this be set for exam.
Discovery is complete on both matters.
I believe so.
Do people have their witnesses available on both cases July 2nd?
Judge, may I address bond briefly?
Okay.
Mr. Dillard is the sole provider he's got 4 kids, ages 2 to 13. He would like to get back to his job at construction. He could live with his mother in Belleville. He will have no contact with the victim, who is the mother of the 4 kids. That being said, Your Honor, we're asking that the court reduce the $25,000 bond, which I believe set in both cases substantially. We'd ask that PR bond released if need be.
Judge, these are cases that happened within a day from each other. On June 9th, the victim, the 13-year-old child was present. She was the one that actually called 911 in this case. There are obviously serious allegations involving a weapon that he brandished during the DV situation. So I believe bond is reasonable. We had originally asked for a $100,000 bond each case. $25,000 bond was granted. So we have to keep the same.
Judge, just very briefly, it's almost the same incident, Your Honor. Again, I'm not minimizing 2 charges, but it just carried over to the next day. And I believe the weapon was licensed to the victim. All that being said, Judge, we're asking that he be able to support his kids.
Defendant's motion for bond reduction is denied. Bond will continue. Preliminary examination will be set July 2nd, 2024, 9 a.m. before Judge Washington.
This keeps the tone sharp, natural, and easy to understand while making it flow smoothly. Clip 2. Another heartfelt request for a bond reduction. Because nothing says responsible parent like allegedly brandishing a weapon during a domestic dispute. Meanwhile,
Just from the heart. Judge, I know you've made your decision, but my client is asking me to ask you. He promises not to have contact with the victim. But I'll be, whatever you're going to say, what are you going to say?
Judge, I know you don't know me, and the situation at hand, I just go backwards. I made a lot of strides through here. Not be in this position. I worked real hard not to even be coming back to the situation. If you can just grant me house arrest, other something, I'll be in jail. It's like
Here's what I know, and you're right, I don't know you. Here's what I know. The allegations that have come before the court is that there is a domestic violence situation which precipitated itself or continued into another day and involved a firearm. That's what I know.
You're not
it never involved.
Judge, for what it's worth, the firearm was found. There was no evidence that a firearm was pointed at anybody. It's just that a firearm was
My
found.
understanding is it was brandished.
Oh,
Judge, I don't believe that at all.
it was found.
It was simply found that the weapon was licensed to the victim.
My ruling stays.
I'm sorry?
My ruling stays.
Thanks, Judge.
Oh, you want me to change it?
Oh,
I will do more than that if you want me to.
Thank you, Judge. We appreciate it.
Yes, I'm serious. Dead serious.
Are you serious?
No, he's lucky I had water because that could have gotten bad. Thank you, Ann.
the judge, probably resisting an eye roll, just denies it. Bond stays. Case moves forward. Next. This keeps the sarcasm intact while making it flow naturally and